Hello everyone. When we were discussing about the attachment provisions, there was a question asked by one of the students that was at the end of the class that attachment before judgment in a civil case, how does it differ from a case which is in a revenue court? So, Siddharth Babu had asked me a question that revenue courts disputes, how do they differ from, or how does the attachment differ in both? The revenue courts have a different special kind of jurisdiction which you learn under the land laws. So, the revenue laws are such laws where whatever dispute comes before, it has to be decided by the special court and the civil courts do not have jurisdiction. But even then, the procedure which is followed before the revenue court is the same procedure which is followed in the civil courts. So, the procedure does not differ. The attachment provisions are according to the provisions which are stated in the civil court itself. Okay. Now, coming to the next topic of our discussion, that is, first of all, we are speaking about interim orders. So, one important interim order which is normally granted whenever a case is before the court and the plaintiff comes with a application or the defendant comes with an application that the property which is the subject matter of the suit is going to be wasted or is going to be damaged by the other side, or there is some reason why it may not remain intact till the end of the case. So, if that happens, the person whoever it may be the plaintiff, it may be the defendant, whoever wins the case or whoever succeeds in the case may not be able to get the remedy or may not be able to be replaced by anything else if that thing is wasted or that property suffers a damage. In such cases, they ask for you must have heard the word status quo. Status quo means let the thing be as it is, status quo. But here we are not speaking of status quo. Going forward, we are speaking about an order of temporary injunction which is granted during the pendency of the suit. So, the provision here is Order 39, Rule 1 to Rule 5 of the Civil Procedure Code speaks about temporary injunctions. Now, temporary injunctions andre ಏನು ಅಂತ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಬೇಕಾದ್ರೆ, ಒಂದು ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇರುವಾಗ ಒಂದು ಕೋರ್ಟ್ ಮುಂದೆ ಕೆಲವು ಪ್ರಾಪರ್ಟಿ ಇರುತ್ತೆ, ಕೆಲವು ಆ ಸ್ವತ್ತು ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತು ಇರುತ್ತೆ, ಅದನ್ನು ಏನಾದರೂ ನಾಶ ಆಗೋ ಸಂಭವ ಇದೆಯಾ ಅಥವಾ ಅದನ್ನು ಏನಾದರೂ ವೇಸ್ಟ್ ಆಗೋ ಸಂಭವ ಇದೆಯಾ ಅಂತ ಯೋಚನೆ ಮಾಡುವಾಗ ನಾವು ಅದನ್ನು ಡಿಸ್ಕಸ್ ಮಾಡ್ತೀವಿ. ಸೊ ಇನ್ ಸಚ್ ಕೇಸಸ್, ಇಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಕೋರ್ಟ್ ಒಂದು ಆರ್ಡರ್ ಕೊಟ್ಟು, ಒಂದು ಆದೇಶ ಕೊಟ್ಟು, ಈ ಪ್ರಾಪರ್ಟಿ ಹೇಗಿದೆ ಅದನ್ನು ವೇಸ್ಟ್ ಮಾಡೋದು ಬೇಡ, ಅದನ್ನು ಮುಂದೆ ಹೋಗಿ ಇಬ್ಬರು ಅದರಲ್ಲಿ ಯಾರಿಗಾದರೂ ಒಂದು ರಿಲೀಫ್ ಸಿಕ್ತು ಅಂದರೆ ಆ ರಿಲೀಫ್ ಪರಿಹಾರ ಅವ್ರಿಗೆ ದೊರಕಬೇಕು, ಈ ಪ್ರಾಪರ್ಟಿ ವೇಸ್ಟ್ ಆಗಿರೋದ್ರಿಂದ ಅವ್ರಿಗೆ ಅವರ ರೈಟ್ಸನ್ನು ಹಾಳು ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳಿ ಒಂದು ಆದೇಶ ಹೊರಡಿಸ್ತಾರೆ. ಇದು ಟೆಂಪರರಿ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್. ಸೊ ತಾತ್ಕಾಲಿಕ ನಿರ್ಬಂಧ ಆಜ್ಞೆ, ಅದು ನಿರ್ಬಂಧ ಹಾಕಿ ಇಂಥ ಕೆಲಸ ಮಾಡಬೇಡ ಅಥವಾ ಇಂಥ ಕೆಲಸ ಮಾಡು, ಸೊ ಇಂಥ ಕಾರ್ಯವನ್ನು ಮಾಡಬೇಡ ಅಥವಾ ಮಾಡು, ದಟ್ ಈಸ್ ಎ ಮ್ಯಾಂಡೇಟ್ ವಿಚ್ ಇಸ್ ಗಿವೆನ್ ಬೈ ದ ಕೋರ್ಟ್. ಸೊ ದ್ಯಾಟ್ ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಡಿಸ್ಕಸ್ ಟುಡೇ. ಅದನ್ನು ನಾವು ಇವತ್ತು ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾ ಇದ್ವಿ. ಸೊ when we speak about interim orders, Order 39, Rule 1 to 5, that is the temporary injunctions. What is the meaning of an injunction? Injunction andre eno? Injunction can be defined in this manner. It is not a definition, it is a meaning. Of course, definition goes still deeper. Injunction is a judicial process by which a party is required to do or to refrain from doing any particular act. ಒಂದು ಜುಡಿಷಿಯಲ್, ಒಂದು ನ್ಯಾಯಿಕ ಒಂದು ಪ್ರಕ್ರಿಯೆ, ಆ ಪ್ರಕ್ರಿಯೆಯಿಂದ ಒಬ್ಬ ಪಕ್ಷಕಾರ ಒಂದು ಕಾರ್ಯವನ್ನು ಮಾಡಬೇಕು ಅಂತ ಹೇಳುತ್ತೆ ಅಥವಾ ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳುತ್ತೆ. ಎನಿ ಜುಡಿಷಿಯಲ್ ಪ್ರೊಸೆಸ್ ಮೀನ್ಸ್ ಇಟ್ ಮೇ ಬಿ ಅನ್ ಆರ್ಡರ್ ಆಫ್ ದ ಕೋರ್ಟ್ which gives the party that particular command. So there are two kinds, normally two kinds of injunction. One is a prohibitory injunction and the other is mandatory injunction. These are the two main kinds of injunction. Prohibitory anta helidre prohibit means idan madbeda, mandatory andre idan madu. So prohibitory is a order which prohibits a person from doing something. Mandatory means it mandates a person from to do something. So to mandate means to command. So it is an order from the court asking a person to do something that is mandatory, to not to do something which is prohibited. So that is the main classification we can make of a injunction. Now when I spoke about status quo, or I spoke about the things to be remained as it is. So when we say that a case is filed before the court, normally what happens, till the end of the proceeding or till the end of the particular suit, that is when a judgment is granted and the decree is granted, till that the subject matter of that suit should be maintained as it is. It should not be disturbed, because if it is disturbed, in the end what happens is, if he gets a remedy also, he is not able to fulfill, or he is not able to fulfill his purpose or take advantage of anything which is in his favor. So what is the remedy for that? So here a stay may be granted or an injunction may be given. What is a stay? What is an injunction? Stay is something which stops anything from moving further. Stay andre hage iro. Injunction means idan madbeda athwa madu. So stay is be as it is. Injunction means stop or do something. Stop doing or do not do or do something. So there is a difference between stay order and an injunction. What is that difference? The difference is that stay means stoppage or suspension of judicial proceeding. Suppose a judicial proceeding is going on and he goes to the high court. The higher court will grant a stay. So the high court will say to the lower court that you do not proceed further. That is the meaning of stay. Order of stay is addressed to the court, not to the person. Okay, and it is once it is granted by a higher court, it is communicated to the court which is to stay, and after it is communicated, it comes to operation. That is the main things, essentials of a stay. Versus injunction, it restrains a person, not a court. It is an order which restrains a person from doing some action or asks a person to do some action. It does not give the order to the court, it gives it to the person. That is the main difference. Secondly, the order of the stay is issued, order of an injunction is issued to a party and asks a party not to do something. And the difference between the two is, when it is communicated, stay comes into operation, but the injunction comes into effect as soon as it is issued by the court. So once the court issues an injunction and you do something which goes against that order, then you can be guilty of contempt of court, because you are not following the court's order. So injunction immediately, whether it is communicated to that person or not, if a court gives a stay, gives an injunction or grants an injunction, it means that it has to be followed. As soon as it is issued, the injunctions comes into operation. Then we can look into the different kinds of injunction. One is a temporary injunction, which is granted by the Civil Procedure Code, Order 39. You have studied about one more permanent injunction in the Specific Relief Act. What are the conditions of granting a permanent injunction? So temporary injunction we are dealing with under the provisions of the Civil Procedure Code, and permanent injunction we deal with under the provisions of the Specific Relief Act. Here Temporary means the person cannot do that act temporarily. not that he is restrained forever. But in permanent injunction, he is restrained forever. He cannot do that act at all. Once that permanent injunction is granted, he cannot do that act. But temporary, it is only for the period of the pendency of the suit. As long as the suit is pending, he is going to have some restriction. But the permanent injunction, even after the conclusion of the trial, it will be granted at the time of conclusion, not in between. And at the end it will be granted, and it will be remaining in effect afterwards forever. So temporary ಒಂದು ತಾತ್ಕಾಲಿಕ ಆಜ್ಞೆ ಅಥವಾ ಪರ್ಮನೆಂಟ್ ಆಜ್ಞೆ. ತಾತ್ಕಾಲಿಕ ಅದೇ ಒಂದು ಕೋರ್ಟ್ ಮುಂದೆ ಒಂದು ಕೇಸ್ ಇರುವಾಗ ಅದು ಜಾರಿಗೆ ಬಂದಿರುತ್ತೆ, ಅಲ್ಲಿವರೆಗೆ ಮಾತ್ರ ಅದು ಜಾರಿಯಲ್ಲಿ ಇರುತ್ತೆ. ಮತ್ತು ಈ ಸೂಟ್ ಪೆಂಡೆನ್ಸಿನಲ್ಲಿ ಇರುತ್ತೆ. ಅದು ಪರ್ಮನೆಂಟ್ ಇದ್ದಾಗ ಇದು ಕಂಪ್ಲೀಟ್ಲಿ ಅವನ ಲೈಫ್ ಲಾಂಗ್ ಅವನು ಅದನ್ನು ಪಾಲಿಸಬೇಕು. ಒಂದು ಕೋರ್ಟಲ್ಲಿ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದರೆ ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ಗೆ ಫೈನಲಿ ಅದು ಕೊನೆಯಲ್ಲಿ ಗ್ರಾಂಟ್ ಆಗುತ್ತೆ. ಇದು ಮೊದಲೇ ಗ್ರಾಂಟ್ ಆಗುತ್ತೆ, ಅದು ಕೊನೆಯಲ್ಲಿ ಗ್ರಾಂಟ್ ಆಗುತ್ತೆ. ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ಈಸ್ ಆಫ್ಟರ್ ದ ಕನ್ಕ್ಲೂಷನ್ ಆಫ್ ದ ಟ್ರಯಲ್. ದಟ್ ಈಸ್ ದ ಮೇನ್ ಡಿಫರೆನ್ಸ್. Then there is in that only we have a prohibitive or restrictive injunction or a mandatory injunction. ಇದೇ ಇಂಜಂಕ್ಷನ್ನ ಇನ್ನು ಎರಡರಲ್ಲಿ ನಾವು ಕ್ಲಾಸಿಫೈ ಮಾಡ್ಬೋದು. ಪ್ರಿವೆಂಟಿವ್ ಇಂಜಂಕ್ಷನ್ ಆರ್ ಮ್ಯಾಂಡೇಟರಿ ಇಂಜಂಕ್ಷನ್. ಪ್ರಿವೆಂಟಿವ್ ಅಂದರೆ ಯಾವುದೋ ಒಂದು ಕೆಲಸವನ್ನು ಮಾಡೋಕ್ಕೆ ಒಂದು ನಿರ್ಬಂಧ, ಮಾಡಬಾರ್ದು ಅಂತ. ಒಂದು ಕೆಲಸವನ್ನು ಮಾಡು ಅಂತ ಹೇಳುವಾಗ ಅದು ಒಂದು ಕಮಾಂಡ್ ಆಗುತ್ತೆ, ಒಂದು ಆದೇಶ ಆಗುತ್ತೆ, ಅದು ಮ್ಯಾಂಡೇಟ್ ಆಗುತ್ತೆ. So a prohibitive or restrictive injunction restrains that person, whereas mandatory injunction compels him to do something which he should do. Then there are again two kinds of injunction in the temporary injunction itself, which we are discussing in interim orders. So that is ad-interim injunction and interim injunction. ಅಂದರೆ ಮಧ್ಯಾವಧಿ, ಆ ಮಧ್ಯಾವಧಿನಲ್ಲಿ ಮಧ್ಯಾವಧಿ. ಸೊ ಏನಾಗುತ್ತೆ ಅಂದರೆ, ಒಂದು ಪೆಂಡೆನ್ಸಿ, ಒಂದು ಇಂಜಂಕ್ಷನ್ಗೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಅರ್ಜಿಯನ್ನು ಕೊಟ್ಟಿರ್ತಾರೆ. ಆ ಇಂಜಂಕ್ಷನ್ ಅರ್ಜಿ ಡಿಸೈಡ್ ಆಗೋದು ಮುಂಚೆ ಏನಾದರೂ ಆಗ್ಬೋದು. ಇದು ಅರ್ಜೆನ್ಸಿ, ಇದು ಆ ಸಮಯದಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಂದರೆ ಅವನು ಇಂಜಂಕ್ಷನ್ ಗ್ರಾಂಟ್ ಆಗೋದು ಮುಂಚೆನೇ, ಆ ತಡೆಯಾಜ್ಞೆ ಗ್ರಾಂಟ್ ಆಗೋದು ಮುಂಚೆನೇ ಅವನು ಏನಾದರೂ ಮಾಡ್ಬೋದು. ಇಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಡ್ಯೂರಿಂಗ್ ದ ಪೆಂಡೆನ್ಸಿ, ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡೆನ್ಸಿ ಇರುವಾಗಲೇ ಆ್ಯಡ್ ಇಂಟ್ರೀಮ್ ಕೊಡ್ಬೋದು. ಇಂಟ್ರೀಮ್ ಮೀನ್ಸ್ ಈ ಅಪ್ಲಿಕೇಶನ್ ಡಿಸೈಡ್ ಆಗೋ ಸಮಯದಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಬರುತ್ತೆ. ಈ ಅಪ್ಲಿಕೇಶನ್ನಲ್ಲಿ ಇಬ್ಬರು ಪಾರ್ಟೀಸು ಕೇಳಿಕೆನ ಕೇಳಿಬಿಟ್ಟು, ಅವ್ರ ಹೇಳಿಕೆನ ಕೇಳಿಬಿಟ್ಟು ಅದರಲ್ಲಿ ಏನು ಒಂದು ನಿರ್ಣಯ ತಗೋಬೇಕು ಅದು ಕೋರ್ಟ್ ನಿರ್ಣಯ ತಗೊಂಡು ಡಿಸೈಡ್ ಮಾಡುತ್ತೆ. ಅದು ಇಂಟ್ರೀಮ್ ಇಂಜಂಕ್ಷನ್. ಸೊ ಆ್ಯಡ್ ಇಂಟ್ರೀಮ್ ಕ್ಯಾನ್ ಬಿ ಗಿವೆನ್ ವೆನ್ ದ ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ಪೆಂಡಿಂಗ್. If there is a fear that something may be done by the other party even during the pendency of that injunction proceeding also, because once a application for the injunction is given or presented before the court, first the court decides that application, then it goes to the merits of the case. Merits are not decided. First, as soon as the person applies for injunction, whether he is a plaintiff or a defendant, then it is decided. Before that, when it is deciding, or when the notice is given to the other person, both of them argue before the court. In that period, he may do something. If that is a possibility, then ad interim injunction is immediately granted. Interim injunction is granted at the end of that application when it is decided by the court, and that operates temporarily throughout the suit. So this is the difference which is relating to injunction. Who may apply? As I said just now, it may be a plaintiff who applies against the defendant, or defendant applies against the plaintiff. But injunction cannot be issued against a stranger or a third party, or it cannot be issued against a court or judicial officer. ಇದು ವಾದಿ ಪ್ರತಿವಾದಿಯ ವಿರುದ್ಧ ಕೇಳ್ಬೋದು, ಪ್ರತಿವಾದಿ ವಾದಿಯ ವಿರುದ್ಧ ಕೇಳ್ಬೋದು. ಆದರೆ ಈ ತಡೆಯಾಜ್ಞೆ ಒಬ್ಬ ಗೊತ್ತಿಲ್ಲದೆ ಇರೋವಂಥ ಥರ್ಡ್ ಪಾರ್ಟಿ, ಮೂರನೇ ವ್ಯಕ್ತಿಯ ವಿರುದ್ಧವಾಗಿ ಕೇಳೋಕ್ಕಾಗಲ್ಲ. ಪಾರ್ಟಿ ಇಲ್ಲದೆ ಇರೋ ಅಂಥ ವ್ಯಕ್ತಿಯ ಮುಂದೆ ಅಥವಾ ಅವರ ಅಗೇನ್ಸ್ಟ್ ಕೇಳೋಕ್ಕಾಗಲ್ಲ, ಅಥವಾ ನ್ಯಾಯಾಲಯ ವಿರುದ್ಧ ಅಥವಾ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ ವಿರುದ್ಧ ನ್ಯಾಯಿಕ ಆಫೀಸರ್ ವಿರುದ್ಧ ಕೇಳೋಕ್ಕಾಗೋದಿಲ್ಲ. ದಟ್ ಈಸ್ ಓನ್ಲಿ ಥಿಂಗ್. ಅಫ್ಕೋರ್ಸ್ ನ್ಯಾಯಾಲಯ ವಿರುದ್ಧವಾಗಿ ನೀವು ಕೇಳಬೇಕಾದ್ರೆ ದೆನ್ ಯು ನೋ ದ್ಯಾಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಅಪ್ಲೈ ಫಾರ್ ಎ ರಿಟ್ to the Supreme Court or the High Court, which gives a order of prohibition or certiorari. That there it applies, and even any other orders. But this CPC provision does not apply to a court or a judicial officer. Then Coming to Order 39 Rule 1, what are the grounds of giving a injunction? So when we speak of Rule 1 here, it says cases in which temporary injunction are to be granted, may be granted. So when in any suit it is proved by affidavit or otherwise, it says. So in what cases the court can grant? When in any suit a person files an application with an affidavit, ಯಾವುದೇ ಒಂದು ಕೇಸಲ್ಲಿ ಒಂದು ಅಫಿಡವಿಟ್ ಜೊತೆಲೆ ಒಂದು ಅರ್ಜಿಯನ್ನು ಕೊಟ್ಟಾಗ ಆಗ ಪರ್ಸನ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಇಟ್ ಮೇ ಬಿ ಎನಿಬಡಿ, ಡಿಫೆಂಡೆಂಟ್ ಆರ್ ಪ್ಲೇಂಟಿಫ್, that any property in a dispute or a suit is in a danger of being wasted. So what the provision says, it is the property is being wasted, damaged or alienated by any party to the suit, or wrongfully sold in execution of the suit, in execution of a decree. Suppose he has already got a decree, a person has already got a decree in some other suit, and now we have filed another case, or maybe it is a case for permanent injunction, or it is a given to declare the rights. ಬೇರೆ ಯಾವುದೇ ಕಾರಣಕ್ಕೆ ಒಂದು ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ, ಆಲ್ರೆಡಿ ಒಂದು ಡಿಕ್ರಿ ಬಂದ್ಬಿಟ್ಟಿದೆ. ಸೊ ಇನ್ ದ್ಯಾಟ್ ಡಿಕ್ರಿ he has got a right, so he may try to sell it wrongfully, means still it is pending before the court. At that time the person tries to wrongfully sell that property, or the opposite party tries to damage the property or alienate it, that is, it is in his possession maybe, and you have asked for a possession from him. ಯಾವುದೇ ಒಂದು ಭೂಮಿನ ಅಥವಾ ಒಂದು ಇದನ್ನು ಪ್ರಾಪರ್ಟಿನ ಸೊತ್ತನ್ನು ಅವರ ಎದುರು ಪಕ್ಷದ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದೆ, ಅದನ್ನು ನನಗೆ ಸ್ವಾಧೀನತೆ ಬೇಕು ಅಂತ ಕೇಸ್ ಹಾಕಿದಾಗ ಅವನು ಅದನ್ನು ಸೇಲ್ ಮಾಡೋಕ್ಕೆ ಪ್ರಯತ್ನ ಪಟ್ಟಿದ್ರೆ, ಅಕಸ್ಮಾತ್ ಅದು ಸೇಲ್ ಆಯಿತು ಅಂತಂದರೆ ಈ ಕೋರ್ಟ್ ಕೇಸ್ ನಿಕಾಲ್ ಆಗೋದು ಮುಂಚೆ ಏನಾದರೂ ಅದಕ್ಕೆ ವೇಸ್ಟ್ ಆಯಿತು, ಡ್ಯಾಮೇಜ್ ಆಯಿತು ಅಂದರೆ ಇವನಿಗೆ ಏನು ರಿಲೀಫ್ ಸಿಗೋದಿಲ್ಲ. ಸೊ ಇನ್ ಸಚ್ ಕೇಸಸ್ where any property is in dispute, which is in dispute, that property should be in a danger of being wasted, not any other property. ಯಾವ ಪ್ರಾಪರ್ಟಿ ಡಿಸ್ಪ್ಯೂಟಲ್ಲಿ ಇದೆ ಆ ಪ್ರಾಪರ್ಟಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು. ಸೊ ವೇರ್ ಇಟ್ ಈಸ್ ಬೀಯಿಂಗ್ alienated by a person, then he can apply for injunction. Secondly, if the defendant threatens, ಇಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ ಅರ್ಥ ಏನು ಅಂತಂದರೆ, ಈ ಇಂಜಂಕ್ಷನಲ್ಲಿ ಎದುರು ಪಕ್ಷ ಇರೋರ ವ್ಯಕ್ತಿನ ನಾವು ಡಿಫೆಂಡೆಂಟ್ ಅಂತ ಹೇಳ್ತೀವಿ ಇಲ್ಲಿ, ನಾಟ್ ದ ಡಿಫೆಂಡೆಂಟ್ ಇನ್ ದ ಸೂಟ್. See, the person who files for injunction, here we are referring to him as a plaintiff. The person who is against, we are referring to him as a defendant. So edur paksha, where a defendant threatens or intends to remove or dispose of his property with a view to defrauding his creditors, avana creditors na ಸಾಲ ಪಡ್ಕೋಬೇಕು, ಸಾಲ ಪಡ್ಕೊಂಡಿದ್ದಾನೆ, ಅದನ್ನು ರಿಕವರಿ ಬೇಕು, ಅಮೌಂಟ್ ಬರಬೇಕು ಅಂತ ಹೇಳಿ ಕೇಸ್ ಹಾಕಿದಾಗ ಈ ಸಾಲ ತಗೊಂಡಿರುವಂಥ ವ್ಯಕ್ತಿ ತನ್ನ ಪ್ರಾಪರ್ಟಿಯನ್ನು ಡಿಸ್ಪೋಸ್ ಮಾಡಿಬಿಡ್ತೀನಿ, ನಾನು ಸೇಲ್ ಮಾಡ್ತೀನಿ ಅಂತ ಅವನು ಥ್ರೆಟನ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ, ಅವನು ಭಯ ಕೊಡ್ತಾ ಇದ್ದಾನೆ. ಅವನು ಮಾಡ್ತಾನೋ ಇಲ್ವೋ, ದಟ್ ಈಸ್ ಅ ಡಿಫ್ರೆಂಟ್ ಥಿಂಗ್, ವೆದರ್ ಹಿ ಡಸ್ ಇಟ್ ಆರ್ ನಾಟ್. ಬಟ್ ಇಫ್ ಹಿ ಥ್ರೆಟನ್ಸ್ ಟು ರಿಮೂವ್ ಹಿಸ್ ಪ್ರಾಪರ್ಟಿ ಆರ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಹಿಸ್ ಪ್ರಾಪರ್ಟಿ so that the creditors will be defrauded, in such cases the injunction can be granted. Then when a defendant threatens to dispossess or tries to cause any injury to the plaintiff relating to the property, he is trying to interfere with the property, he is trying to cause any injury to the plaintiff, in such cases also the temporary injunction may be granted, and then the court will pass an order granting a temporary injunction to restrain such act, or make such other order for the purpose of staying and preventing the wasting, damaging, alienation, sale, removal or disposition of the property, or otherwise causing injury to the plaintiff in relation to the property in dispute, or as the court thinks fit, until the disposal of the court or of the suit or otherwise. ಸೊ ಈ ಡ್ಯಾಮೇಜ್ ಆಗೋದು, ಈ ವೇಸ್ಟ್ ಆಗೋದು, ಇದನ್ನು ತಡೆ ಮಾಡಬಹುದು ಕೋರ್ಟು. ಒಂದು ಆದೇಶ ಕೊಟ್ಟು ಇದನ್ನು ಮಾಡಬೇಡ ಅಂತ ಹೇಳ್ಬೋದು, ಅಥವಾ ಈ ಕೇಸು ಆಗೋ ತನಕ ಈ ಇಂಜಂಕ್ಷನ್ನ ಹಾಗೆ ಇದನ್ನು ಒಂದು ತಡೆ ಆಜ್ಞೆಯನ್ನು ಕೊಟ್ಟು ಇದನ್ನು ನಿರ್ಬಂಧ ಹಾಕ್ಬೋದು ಪ್ಲೇಂಟಿಫನ್ನು. ಹಾಗೆ ಸ್ಟೇಟಸ್ ಕೋ ಮಾಡಿ ಅಂತಾನು ಜೊತೆಲೆ ಹೇಳ್ಬೋದು. ಲೆಟ್ ಇಟ್ ಬಿ ಆಸ್ ಇಟ್ ಈಸ್ ಅಂತ ಹೇಳ್ಬೋದು. ಸೊ ದೀಸ್ ಆರ್ ಆಲ್ ದ ಮೆಥಡ್ಸ್ ವಿಚ್ ಆರ್ used interim so that the person may be assured that his property is kept as it is and it is not wasted or damaged. So there are other grounds also wherein under rule 2, that is injunction to restrain repetition or continuance of breach. Rule 2A says that where in any suit for restraining the defendant for committing a breach of contract or other injury, whether compensation is claimed or not, the plaintiff may at any time after the commencement of the suit, either before or after judgment, apply to the court for a temporary injunction to refrain the defendant from committing the breach of contract or injury complained of, or any breach of contract of a like kind arising of the same contract. See, for example, there is a breach of contract. So he has agreed to do something and he is about to commit a breach of contract or he is about to do some injury. Suppose already there is an injunction asking him not to breach the contract, and then further he goes and tries to do something which is amounting to breach of the contract, then the injunction may be granted. This injunction may be granted even after the suit is decided, but here according to the specific relief act also we have studied about this. Then the breach of contract should be not continued. For that purpose the court may give this injunction. Then under section 94C, the court also says that where a court is of opinion that the interest of justice so requires, it may grant an injunction. Besides all this, whenever the court thinks that justice requires that it should be granted. ಸೊ ನ್ಯಾಯ ನಿರ್ವಹಣೆಗೋಸ್ಕರ ಇದು ಬೇಕಾಗಿದೆ, ಇದು ಅವಶ್ಯಕವಿದೆ ಅಂತ ಹೇಳಿದಾಗ ಈ ನಿರ್ಬಂಧಾಜ್ಞೆಯನ್ನು ಕೋರ್ಟ್ ಆದೇಶ ಮಾಡಬಹುದು. ಈ ಆದೇಶ ಕೊಡುವಾಗ ಎನಿ ಕಂಡೀಷನ್ಸ್, ಯಾವುದೇ ಒಂದು ಕಂಡೀಷನ್ನ ಹಾಕ್ಬೋದು. ಸೊ ವೆನ್ ದ ಕೋರ್ಟ್ ಗ್ರಾಂಟ್ಸ್ ಸಚ್ ಇಂಜೆಕ್ಷನ್ ಆನ್ ಸಚ್ ಟರ್ಮ್ಸ್ ಟು ದ ಡ್ಯೂರೇಷನ್ ಆಫ್ ದ ಇಂಜೆಕ್ಷನ್, ಕೀಪಿಂಗ್ ಅನ್ ಅಕೌಂಟ್, ಗಿವಿಂಗ್ ಸೆಕ್ಯೂರಿಟಿ ಆರ್ ಎನಿಥಿಂಗ್, ನೀನು ಭದ್ರತೆ ಕೊಡು ಅಂತ ಹೇಳ್ಬೋದು, ಒಂದು ಅಕೌಂಟ್ ಇಡು ಅಂತ ಹೇಳ್ಬೋದು, ವಾಟ್ ಎವರ್ ರೀಸನ್ಸ್, ದ ಕೋರ್ಟ್ ಮೇ ಗ್ರಾಂಟ್ ಅನ್ ಇಂಜೆಕ್ಷನ್ ವಿತ್ ದ ಕಂಡೀಷನ್ಸ್ ಆಫ್ ದಟ್. So this is the injunction which is granted by the court and which are in what conditions it can be granted. Now here there are several cases before the court where the court has to decide. See, the court may grant anta heluvaga, this is a discretionary remedy, is it not? This is a discretionary remedy. ಇದು ಒಂದು ವಿವೇಚನಾಧಿಕಾರ ಇರೋದು. ಸೊ ಈ ವಿವೇಚನಾಧಿಕಾರ ಚಲಾಯಿಸುವಾಗಲೂ ಅದನ್ನು ಕೋರ್ಟು ಒಂದು ಯಾವುದೇ ಒಂದು ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಇಡಬೇಕು, ಯಾವ ರೀತಿಯಲ್ಲಿ ಈ ಇಂಜೆಕ್ಷನ್ ಕೊಡಬೇಕು, ಯಾವ ಕಂಡೀಷನಲ್ಲಿ ಕೊಡಬೇಕು. ಇಟ್ ಈಸ್ ನಾಟ್ ಜಸ್ಟ್ ಆರ್ಬಿಟ್ರರಿಲಿ ಫಾರ್ ದ ಕೋರ್ಟ್ ಟು ಡಿಸೈಡ್ ದಟ್ ಇನ್ ದಿಸ್ ಕೇಸ್ ಐ ಹ್ಯಾವ್ ಟು ಗ್ರಾಂಟ್ ಇಂಜೆಕ್ಷನ್, ಇನ್ ದಿಸ್ ಕೇಸ್ ಐ ಕೆನಾಟ್ ಗ್ರಾಂಟ್ ಇಂಜೆಕ್ಷನ್. ದೇ ಮಸ್ಟ್ ಬಿ ಸಮ್ principles on which the injunction has to be granted by the court, because once the person is restricted from doing something, it is again a restriction on his privacy, on his own rights, on his liberty. So this has to be done with caution and care. So what are the principles? Looking into several cases, we can find out that before granting an injunction there are certain things to be considered before the court. ಯಾವುದೇ ಇಂಜಂಕ್ಷನ್ ಕೊಡುವಾಗ ಕೆಲವು ಪ್ರಿನ್ಸಿಪಲ್ಸ್ನ, ಕೆಲವು ತತ್ವಗಳನ್ನು ಕೋರ್ಟು ಅನ್ವಯಿಸಬೇಕು. ತಾನೇ ಹಾಗೆ ಮನಸ್ಸು ಬಂದಂಗೆ ಇದನ್ನು, ಈ ಪವರ್ನ ಚಲಾಯಿಸೋಕ್ಕಾಗಲ್ಲ. ಕೋರ್ಟ್ಗೆ ಒಂದು ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಮೇಂಟೈನ್ ಮಾಡಬೇಕು, ಯಾವ ರೀತಿಯಲ್ಲಿ ಯೋಚನೆ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ ಸುಮಾರು ಕೇಸಸಲ್ಲಿ ಈ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ನ ಲೇ ಡೌನ್ ಆಗಿದೆ. ಈ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಇವಾಗ ಕಡ್ಡಾಯವಾಗಿ ಎಲ್ಲ ಕೋರ್ಟ್ಸು ಫಾಲೋ ಮಾಡುತ್ತೆ ಯಾವಾಗ ಈ ಇಂಜಂಕ್ಷನ್ ಪ್ರಶ್ನೆ ಬರುತ್ತೆ. ದಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಆ್ಯಸ್ ಎ ಟ್ರಿಪಲ್ ಟೆಸ್ಟ್. ಇದು 3 ಪ್ರಶ್ನೆಗಳನ್ನು ಕೋರ್ಟ್ ತನಗೆ ಕೇಳಬೇಕು. ಈ 3 ಪ್ರಶ್ನೆ ಕೇಳಿ ಇದಕ್ಕೆ ಉತ್ತರ ಏನು ಬರುತ್ತೆ ಅದರ ಬೇಸಿಸ್ ಮೇಲೆ, ಅದರ ಆಧಾರದ ಮೇಲೆ ಇಂಜೆಕ್ಷನ್ ಹಾಕಬೇಕು. ದೀಸ್ 3 questions ಆರ್ ಟು ಬಿ ಆಸ್ಕ್ಡ್ ಬೈ ದ ಕೋರ್ಟ್ ಟು ಇಟ್ ಸೆಲ್ಫ್ ಬಿಫೋರ್ granting an injunction. First of all, whether the plaintiff has a prima facie case. ಮೇಲ್ನೋಟಕ್ಕೆ ಪ್ಲೇಂಟಿಫ್ ಪರವಾಗಿ ಕೇಸ್ ಇದೆಯಾ, ಪ್ಲೇಂಟಿಫ್ ಪರವಾಗಿ ರೈಟ್ಸ್ ಇದೆಯಾ ಮೇಲ್ನೋಟಕ್ಕೆ. the court does not go into the merits of the case. Okay, it looks into the case. Secondly, whether the plaintiff would suffer irreparable injury if his prayer for temporary injunction is not granted. Suppose the court does not give this injunction, whether that injury which is caused to the plaintiff, plaintiff means the person who has applied for the injunction, okay, he may be the defendant also, but for the purpose of the injunction he is called as a plaintiff. So whether he will suffer any injury if his prayer is not granted. Second question. Third question, now both will suffer some inconvenience. Whatever happens, both the plaintiff and defendants are going to suffer some inconvenience. Now what is the balance of that convenience, and is it in favor of the plaintiff or is it in the favor of the defendant? ಇಬ್ಬರಿಗೂ ಏನಾದರೂ ಒಂದು ತೊಂದರೆ ಆಗುತ್ತೆ, ಇಬ್ಬರಿಗೆ ಈ ಇಂಜೆಕ್ಷನ್ ಕೊಟ್ಟಾಗ, ನಿರ್ಬಂಧಾಜ್ಞೆ ಕೊಟ್ಟಾಗ ಇಬ್ಬರಿಗೆ ಒಂದು ಅನನುಕೂಲತೆ ಆಗುತ್ತೆ. ಆ ಅನನುಕೂಲತೆ ಯಾರಿಗೆ ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಅದನ್ನು ಆ ಬ್ಯಾಲೆನ್ಸು ಕೋರ್ಟ್ ನೋಡಬೇಕು. ದಟ್ ಈಸ್, ದೀಸ್ ಆರ್ ದ 3 different questions which come to the mind of the court, and the court has to answer that in order to give an injunction. Besides that, there are other factors like interest of justice and whether, looking into that facts of the case, whether this requires an injunction or not. So these are also the other factors, but these are the main factors. So ಈ ಟ್ರಿಪಲ್ ಟೆಸ್ಟನ್ನು ನೋಡಬೇಕು. ಫಸ್ಟ್ ಆಫ್ ಆಲ್, ಪ್ರೈಮಾ ಫೇಸಿ ಕೇಸ್ ಅಂದರೆ ಏನು? ವಾಟ್ ಈಸ್ ದ ಮೀನಿಂಗ್ ಆಫ್ ಪ್ರೈಮಾ ಫೇಸಿ ಕೇಸ್? Prima facie means on the face of it. On the face of it, looking at the case. How the court looks at the case? When that the plaintiff comes to the court with the, or the he comes with court with the application saying that these are the facts. Looking into those facts, not relating to the merits. We are not speaking about the evidence of the case. We are not speaking about what evidence will be given by that person at the time of the trial or at the time of giving evidence. ನಾವು ಎವಿಡೆನ್ಸ್ ಸಮಯದಲ್ಲಿ ಅವನು ಏನು ಕೊಡ್ತಾನೆ ಅದನ್ನು ನೋಡ್ತಾ ಇಲ್ಲ. ಕೋರ್ಟ್ ಏನು ನೋಡಬೇಕಂದ್ರೆ, ಈ ಏನು ಅವನು ಸಂಗತಿಗಳನ್ನು ಹೇಳಿದ್ದಾನೆ, ಆ ಸಂಗತಿಗಳ ಪ್ರಕಾರ ಅವನಿಗೆ ಏನು ನಿರ್ಬಂಧಾಜ್ಞೆ ಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾನೆ, ಅದು ಕೊಡೋಕ್ಕೆ ಮೇಲ್ನೋಟಕ್ಕೆ ಅದು ಸಾಧ್ಯವಿದೆಯಾ ಒಂದು. ಪ್ರೈಮಾ ಫೇಸಿ ಕೇಸ್ ಅಂತಂದರೆ, ಈ ಕೇಸ್ ಏನು ಅವನು ಹಾಕಿದ್ದಾನೆ, ಕೊನೆಯದಾಗಿ ಅವನು ಅದರಲ್ಲಿ ಸಕ್ಸಸ್ ಆಗೋದು ಅಥವಾ ಅವನ ಪರವಾಗಿ ರೈಟ್ಸ್ ಡಿಕ್ಲೇರ್ ಆಗೋ ಅಂಥ ಚಾನ್ಸ್ ಇದೆಯಾ? ಸಿ, ದ ಕೋರ್ಟ್ ಡಸ್ ನಾಟ್ ಹ್ಯಾವ್ ಎ ಪ್ರೆಜುಡಿಸ್ ದಟ್ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಗಿವ್ ಇನ್ ಫೇವರ್ ಆಫ್ ದಟ್ ಪರ್ಸನ್ ಓನ್ಲಿ. ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಡಿಸೈಡ್ ದಿಸ್ ಕೇಸ್ ಇನ್ ದ ಫೇವರ್ ಆಫ್ ಐದರ್ ದ ಪ್ಲೇಂಟಿಫ್ ಆರ್ ಡಿಫೆಂಡೆಂಟ್. ದ ಕೋರ್ಟ್ ವಿಲ್ ನಾಟ್ ಡಿಸ್ಕಸ್ ಅಬೌಟ್ ದ್ಯಾಟ್. The court will not look into the details of the matter, but just the facts of that case, whatever case has been put before the court will look into the case and decide whether in the end, when deciding the case, this person who has applied for the injunction, whether he is entitled to the relief or not. Now, for example, he claims for possession of a property, and he gives the papers. He gives an affidavit, he gives the papers, documents to the court showing that he is the owner of the property. Now, when the court looks into that matter, he comes to know that this person is the owner of the property, and therefore if the property is damaged or anything by the other person, and that other person he is claiming that he is in wrongful in possession. So, as those documents show that he is having the ownership, that means he has a right to that relief. Whether he proves in the end or not is not discussed, but suppose he proves, what happens? So, whether there is a chance of deciding, or whether there is a chance of winning that case. For example, in one case, there was a application for injunction, that is Dalpat Kumar versus Prahlad Singh, All India Reporter 1993. Supreme Court. In that case, the court has said that, and one more case, that is Martin Byrne Limited versus R.N. Banerjee. That was an old case, All India Reporter 1957, where the prima facie case was explained by the court. The court says that a prima facie case does not mean the case proved to the hilt. ಅಂದರೆ ನೀವು ಅವನ ಕೇಸನ್ನು ಕೊನೆಯವರೆಗೆ ಎಲ್ಲ ತಪಾಸಣೆ ಮಾಡಿ ಈ ರೀತಿ ಪ್ರೂವ್ ಮಾಡಬೇಕು ಅಂತ ಏನಿಲ್ಲ. ಪ್ರೂವ್ ಮಾಡಿ ಹೌದು ಇದು ಪ್ರೂವ್ ಆಗುತ್ತೆ ಅಂತ ಯೋಚನೆ ಮಾಡೋದು ಬೇಕಾಗಿಲ್ಲ. ವೈಲ್ ಡಿಸೈಡಿಂಗ್ ಎ prima facie case, the court will look into the materials which are given by the plaintiff, whatever materials are provided. Looking at that materials and the affidavit of the person, the relevant consideration is whether this evidence, when it is given to the court, it was possible to arrive at the conclusion in question, and not whether that was the only conclusion. See, the court may arrive at some other conclusion. ಇದನ್ನು ಈ ಮೆಟೀರಿಯಲ್ಸ್ ಏನು ಕೊಟ್ಟಿದ್ದಾನೆ ಅವನು, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇರ್ಬೋದು, ಏನಾದರೂ ಆ ಕೇಸಲ್ಲಿ ಸಂಗತಿಗಳನ್ನು ಹೇಳಿರ್ಬೋದು, ಈ ಸಂಗತಿಗಳು, ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, ಈ ದಸ್ತಾವೇಜ್ ನೋಡಿದಾಗ ಕೊನೆಯಲ್ಲಿ ಅವನ ಪರವಾಗಿ ಈ ಕೇಸ್ ಆಗುತ್ತೆ ಅಂತ ಸಾಧ್ಯತೆ ಇದೆಯಾ? ಅದೇ ಸಾಧ್ಯತೆ ಇದೆ ಅಂತ ಬರೋದಿಲ್ಲ, ಅದು ಕೊನೆಯಲ್ಲಿ ಬರುತ್ತೆ. ಸಾಧ್ಯತೆ ಇದ್ದರೆ ದೆನ್ he is having a prima facie case. If it is a probability that he is entitled, then it can be given. Then for this, to satisfy the court that prima facie case is in his favor, that burden is on the plaintiff to do that. So plaintiff ಮೇಲೆ ಭಾರ ಇದೆ, ಅವನು ಕೋರ್ಟ್ಗೆ ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಬೇಕು. ಈ ಎವಿಡೆನ್ಸ್ ಏನೇನಿದೆ ಅದು ಕೊಟ್ಟು ನನಗೆ ನನ್ನ ಫೇವರ್ ಆಗಿ ಈ ಕೇಸ್ ಆಗೋ ಚಾನ್ಸ್ ಇದೆ, ಸಾಧ್ಯತೆ ಇದೆ, ಅದರಿಂದ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಸೊ ಮೇಲ್ನೋಟಕ್ಕೆ ಆ ಕೇಸ್ ಅವನ ಪರವಾಗಿ ಆಗುವಂಥ ಒಂದು ಸಾಧ್ಯತೆ ಇರಬೇಕು. ದೇರ್ ಶುಡ್ ಬಿ ಎ ಪ್ರೊಬಬಿಲಿಟಿ ದ್ಯಾಟ್ ದ ಪ್ಲೇಂಟಿಫ್ ವಿಲ್ ಗೆಟ್ ದ ರಿಲೀಫ್ ವಿಚ್ ಹ್ಯಾಸ್ ಆಸ್ಕ್ಡ್ ಅಟ್ ದ ಎಂಡ್ ಆಫ್ ದ case. So that is, once the prima facie case is decided, then only the court will look into the other matters. Otherwise it will not go to the other questions at all. First it will decide whether it is a prima facie case or not. It must precede an order of injunction. Then second consideration of the court is the second question, whether there will be irreparable injury caused to the plaintiff. ಈ ಪಕ್ಷಕಾರ ಯಾರು ನಿರ್ಬಂಧಾಜ್ಞೆ ಕೇಳಿದಾನೆ ಅವನಿಗೆ ರಿಪೇರ್ ಆಗದೇ ಇರುವಂಥ, ಅದು ಪಡಿಸೋಕ್ಕಾಗಲ್ಲ ಅಂಥ ಏನಾದರೂ ಅವನಿಗೆ ನಷ್ಟ ಅಥವಾ ಕಷ್ಟ ಆಗಬಹುದಾ? ಸೊ ಹಿಯರ್ the plaintiff or applicant must satisfy that if the injunction is not granted, he does not have any other remedy. This is the only remedy which he can ask the court. ಇದನ್ನು ಬಿಟ್ಟು ಬೇರೆ ಅವನಿಗೆ ಯಾವುದೇ ಪರಿಹಾರ ಇಲ್ಲ. ಈ ಪರಿಹಾರನೇ ಅವನಿಗೆ ಬೇಕು. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, he is the owner of a property, and if that property is sold wrongfully, what happens? He will lose that property, and finally he will not be able to take it back because another person gets the right. That cannot be repaired by giving him compensation or giving him some damages for that or giving him something in return for that. Court cannot order anything. This is the only remedy which he is having. So he has to prove to the court that irreparable injury will be caused to me. So irreparable injury does not mean that there is no possibility of repairing the injury again. You should be very careful about discussing these things. It means that this injury must be a material injury. It cannot be adequately compensated by damage. ನೋಡಿ, irreparable injury ಅಂತ ಹೇಳಿದ್ರೆ no possibility of repair ಅಂತ ನೀವು ಹೇಳಿದಾಗ, suppose there is a sale of his property and he may later on be ordered to give him some other property in return. So where is the irreparable injury? But the question is not that whether he can be given a material, it can be repaired or not. The question is, if this injury has been caused, can those damages be measured? ಅವನಿಗೆ ಎಷ್ಟು ನಷ್ಟ ಆಗಿದೆ ಅದು ಮೆಜರ್ ಮಾಡೋಕ್ಕಾಗತ್ತಾ? ಅದನ್ನು ಎಷ್ಟು ಅಂತ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡೋಕ್ಕಾಗತ್ತಾ? ಅದು ಪ್ರಶ್ನೆ ಬರುತ್ತೆ. ಇದು ಕ್ಯಾಲ್ಕುಲೇಬಲ್ ಇಲ್ಲವೇ ಇಲ್ಲ ಅಂಥ ಇಂಜುರಿ ಇದ್ದರೆ, ಅಂಥ ಒಂದು ಪೆಕ್ಯುನರಿ ಅಮೌಂಟ್ ನಿರ್ಧಾರ ಮಾಡೋಕ್ಕೆ ಆಗೋದಿಲ್ಲ ಅಂತ ಇದ್ದರೆ, that pecuniary amount cannot be decided. If that injury is such that it cannot be compensated by money or compensated by something which is given to him in form of damages. In such cases, the court will say that it is an irreparable injury and the applicant will be given an injunction, or he will be issued an injunction. This was again discussed in a English case and also in these two cases which we discussed just now. It says that in American Cyanamide Company versus Ethicon Limited, American Cyanamide Company versus Ethicon Limited, there was a question of granting injunction before the House of Lords, and there the court has said that irreparable injury does not mean that there is no possibility of repairing. The injury should be a material one. It cannot be adequately compensated by damages. So both sides are exposed to irreparable injury. What should be done? ಇಬ್ಬರು ಸೈಡ್ಸ್ಗೆ irreparable injury ಆಗುತ್ತೆ ಅಂತ ಕಂಡುಬರುತ್ತೆ. ಇಬ್ಬರು ಪಾರ್ಟೀಸ್ಗೆ ನಷ್ಟ ಆಗಿರೋದನ್ನು ಭರಿಸ್ಕೊಡೋಕ್ಕೆ ಆಗೋದಿಲ್ಲ ಅಂತ ಕ್ವಶನ್ ಬಂದಾಗ ಆವಾಗ ಏನು ಮಾಡಬೇಕು, ಆವಾಗ ಕೋರ್ಟಿಗೆ ಬ್ಯಾಲೆನ್ಸ್ ಮಾಡಬೇಕು. ಇಬ್ಬರದು ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ನೋಡಬೇಕು. ಇಬ್ಬರಿಗೆ ಇವನಿಗೆ ಎಷ್ಟು ಡ್ಯಾಮೇಜ್ ಆಗುತ್ತೆ, ಅವನಿಗೆ ಎಷ್ಟು ಡ್ಯಾಮೇಜ್ ಆಗುತ್ತೆ. ಸೊ ಬ್ಯಾಲೆನ್ಸ್ ಆಫ್ ಕನ್ವೀನಿಯನ್ಸ್, ಬ್ಯಾಲೆನ್ಸ್ ಆಫ್ ಕನ್ವೀನಿಯನ್ಸ್, balance of inconvenience. These are the two words. Actually, in most of the states or most of the cases, the court says that balance of convenience is in the favor of the plaintiff, and then the court gives the reason. But inconvenience, why we say inconvenience, it is more about balance of inconvenience, because how much inconvenience is caused to one person, how much inconvenience is caused to the other person, that has to be looked into the court. Because what is the hardship which is caused to the applicant who has applied for injunction, what is the hardship which is caused to the opposite party. That means if I grant this injunction, okay, the other party is going to be inconvenienced. How much that inconvenience will affect him. If I do not grant this injunction, this party will be affected, the applicant will be affected. How much inconvenience will he suffer? Both have to be balanced. ಈಗ ನಾವು ಈ ಇಂಜಂಕ್ಷನ್ನ ಕೊಟ್ಟಿಲ್ಲ, ತಡೆ ಆಜ್ಞೆ ಕೊಟ್ಟಿಲ್ಲ ಅಥವಾ ನಿರ್ಬಂಧ ಆಜ್ಞೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಂದರೆ ಈ ಅರ್ಜಿದಾರನಿಗೆ ಎಷ್ಟು ಅನನುಕೂಲ ಆಗುತ್ತೆ, ಎಷ್ಟು ಕಷ್ಟ ಆಗುತ್ತೆ, ಎಷ್ಟು ತೊಂದರೆ ಆಗುತ್ತೆ, ಎಷ್ಟು ಹಾರ್ಡ್ಶಿಪ್ ಆಗುತ್ತೆ. ಆದರೆ ಇದನ್ನು ನಾನು ಕೊಟ್ಟಿದ್ರೆ, ಇಂಜಂಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರೆ ಅಥವಾ ನಾವು ಈ ಆದೇಶ ಕೊಟ್ಟಿದ್ರೆ ಈ ಅಪೋಸಿಟ್ ಪಾರ್ಟಿ ಎದುರು ಪಕ್ಷನಿಗೆ ಎಷ್ಟು ಡ್ಯಾಮೇಜ್ ಆಗುತ್ತೆ. ಈ ಎರಡು ಡ್ಯಾಮೇಜಸನ್ನು ಭಾರ ನೋಡಿ ಯಾವುದು ಜಾಸ್ತಿ ಅಂತ ನೋಡಬೇಕು. ಇನ್ ಹೂಸ್ ಫೇವರ್ ದ ಬ್ಯಾಲೆನ್ಸ್ ಆಫ್ ಕನ್ವೀನಿಯನ್ಸ್ ಇಸ್ ದೇರ್. ಸೊ ದ ಬ್ಯಾಲೆನ್ಸ್ ಆಫ್ ಕನ್ವೀನಿಯನ್ಸ್, ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಜಾಸ್ತಿ ಅವನಿಗೆ ಆಗುತ್ತೆ ಅಂದರೆ ಇಂಜೆಕ್ಷನ್ ಕೊಡಬೇಕು. ಆ ಇನ್ಕನ್ವೀನಿಯನ್ಸು ಅಪೋಸಿಟ್ ಪಾರ್ಟಿಗೆ ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ ಕೊಡಬಾರ್ದು. So that is the question which is decided. See, the balance of convenience, when once the plaintiff establishes his prima facie case, then the court will look into the balance of convenience. For example, under the Rent Act, suppose a owner files a case for eviction of the tenant. Okay, in one of our own cases, he files a case to evict the tenant, and he asked that the court to immediately grant an injunction that he should not, he is wasting the property, and he has started putting that property into such a condition that if the injunction is not granted pending that case, if it is not granted, that property will be wasted in such a manner that even though he occupies the property in the end, he may have to suffer a lot of inconvenience, a lot of hardship to restore it to that particular condition. ನಮ್ಮ ಒಂದು ಕೇಸಲ್ಲಿ ಒಂದು ರೆಂಟ್ ಎವಿಕ್ಷನ್ಗೆ ನಾವು ಇದು ಮಾಡುವಾಗ ಗ್ರೇಟರ್ ಹಾರ್ಡ್ಶಿಪ್ ಯಾರ್ದು ಅಂತ ನೋಡುವಾಗ ಆ ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ಇರೋವಂಥ ಟೆನೆಂಟು ಎಂಥ ಸ್ಥಿತಿನಲ್ಲಿ ತಂದುಬಿಟ್ಟಿದ್ದಾನೆ ಅಂದರೆ ಅದನ್ನು ಸರಿಯಾಗಿ ಅವನು ಅಕಸ್ಮಾತ್ ಈ ಕೇಸು ಅವನ ಪರವಾಗಿ ಆದರೂ ಕೂಡ ನಂತರ ಅವನಿಗೆ ತುಂಬ ತೊಂದರೆ ಆಗುತ್ತೆ. ಅದು ಮತ್ತೆ ಅದನ್ನು ಆ ಸ್ಥಿತಿಗೆ ತರೋಕ್ಕೆ ಅವನು ಎಷ್ಟು ಕಷ್ಟಪಡಬೇಕಾಗುತ್ತೆ ಅದನ್ನು ನಾವು ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಿದ್ವಿ. ಸೊ ವಿ ಹ್ಯಾವ್ ಟು, ಇನ್ ದಟ್ ಕೇಸ್ ಇಂಜಂಕ್ಷನ್ ವಿಲ್ ಬಿ ಗ್ರಾಂಟೆಡ್ ದಟ್ ನಾಟ್ ಟು ಡೂ ದೀಸ್ ಥಿಂಗ್ಸ್. ಸೊ ಯು ಡು ನಾಟ್ ಡೂ ದಿಸ್, ಡೂ ನಾಟ್ ವೇಸ್ಟ್, ಡೂ ನಾಟ್ ಡ್ಯಾಮೇಜ್ ದ ಪ್ರಾಪರ್ಟಿ. ಇಂಥ ಕ್ವೆಶನ್ಸಲ್ಲಿ ಸಿ ವೆನ್ ದ ಪರ್ಸನ್ ಈಸ್ ಗೋಯಿಂಗ್ ಟು occupy, he is the owner of the property, he has a right over the property. The rent, the person who has taken on rent, he is only a temporary occupier. So there the balance of convenience is more for the owner or for the plaintiff who is applying for the injunction. So in that way the court will look into. There was one more case where we applied. There was suppose A and B, they are both situated in a property where they have a common wall. ಒಂದು ಕಾಮನ್ ವಾಲ್ ಇದೆ, ಒಂದು ಸಮಾನ ಒಂದು ಗೋಡೆ ಇದೆ, ಈ ಕಡೆ ಒಂದು ಮನೆ ಇದೆ, ಆ ಕಡೆ ಒಂದು ಮನೆ ಇದೆ. ಸೊ ದೇರ್ ಆರ್ ಟೂ ಹೌಸಸ್. ಓಕೆ, ದ ಅದರ್ ಹೌಸ್ ದಟ್ ಈಸ್ ವಿಚ್ ವಾಸ್ ನೆಕ್ಸ್ಟ್ ಟು ದಟ್ ದ ಅಪ್ಲಿಕೆಂಟ್, he was he was constructing the house further. ಇದು ಒಂದು ಇದಿರುತ್ತೆ, ಫ್ಲೋರ್ ಇರುತ್ತೆ, ಸೆಕೆಂಡ್ ಫ್ಲೋರ್ ಕಟ್ತಾ ಇದ್ದಾನೆ. ಸೊ ಹಿ ಈಸ್ ಕನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ದ ಸೆಕೆಂಡ್ ಫ್ಲೋರ್, ಫಸ್ಟ್ ಫ್ಲೋರ್ ಆ್ಯಂಡ್ ಸೆಕೆಂಡ್ ಫ್ಲೋರ್. So in that case what happens, he starts making holes in the common wall. Now when he starts making holes in the common wall for his purpose, what happens is this person will be suffering, because suppose that something damage happens to the common wall, then the person who is on this side, he has no other remedy. He has to be, for no fault of his, he will have to repair that wall which he on his side. He will repair on the other side. What about his side? So there the court has to look into the matter. So the court granted an injunction asking him not to damage the common wall. That was the injunction, not to damage the common wall, because both of the parties are going to use that wall, and therefore the injunction was to restrain from causing any damage to the common wall. For that purpose we even brought an expert to gauge the damage which has been caused and to show before the court. ನಾವು ಎವಿಡೆನ್ಸ್ ಏನು ಕೊಟ್ಟಿದ್ವಿ ಕೋರ್ಟ್ಗೆ ಅಂದರೆ, ಯಾವ ಪದ್ಧತಿನಲ್ಲಿ ಅವನು ಅದನ್ನು ವಯೋಲೇಟ್ ಮಾಡಿದ್ದಾನೆ, ಈಗ ಬಿಲ್ಡಿಂಗ್ ರೂಲ್ಸ್ ಹೆಂಗೆ ವಯೋಲೇಟ್ ಮಾಡಿದ್ದಾನೆ, ಯಾವ ರೀತಿ ಅದನ್ನು ಈಗ ಪಕ್ಕದಲ್ಲಿ ನೇಬರ್ ಇರುವಾಗ ಅವ್ರಿಗೆ ತೊಂದರೆ ಆಗಬಾರ್ದು ಅಂತ ಏನೇನು ಕಾನೂನಿದೆ ಅದನ್ನು ಹೇಗೆ ವಯೋಲೇಟ್ ಮಾಡಿದ್ದಾನೆ. ಈವನ್ ಪಾಯಿಂಟ್ ಆಫ್ ಲಾ ಆ್ಯಂಡ್ ಪಾಯಿಂಟ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ ಬೋತ್ ವೇರ್ ಕನ್ಸಿಡರ್ಡ್. ಕೋರ್ಟ್ ಅದನ್ನು ಎವಿಡೆನ್ಸ್ ನೋಡಿಕೊಂಡು ಅವನಿಗೆ ಇಂಜಂಕ್ಷನ್ ಕೊಡ್ತು. ಸೊ ದಟ್ ಈಸ್ ಹೌ ವಿ ಕ್ಯಾನ್ ಫೈಲ್ ಫಾರ್ ಅನ್ ಇಂಜಂಕ್ಷನ್. ಸೊ ದಿಸ್ ಇಸ್ ಎ ಟೆಂಪರರಿ ಇಂಜಂಕ್ಷನ್. ಇಮಿಡಿಯೇಟ್ಲಿ ಇಟ್ ವಿಲ್ ಬಿ ಗ್ರಾಂಟೆಡ್ at the time of that case when he is asking for that purpose. So there are so many such instances where the court will look into the convenience. avunige akasmat avunige kottilla, suppose the court is not giving him the injunction to build that to restrain, then what happens is he will suffer for such a inconvenience which is very difficult to repair later on. So irreparable injury will be caused. So these are the conditions. So when injunction can be refused, first of all, injunction can be refused if there is a delay on the part of the party or laches or acquiescence on the part of the party. If suppose he just keeps quiet, he acquiesces, then he will not be given the injunction. Where he does not come to court with clean hands, that means he is having some other, in the garb of the injunction, he is having some other motive, then the court will come to know relating to that facts and the court will refuse the injunction. Suppose he suppresses material facts, he doesn't give the actual main facts to the court, he suppresses it, then the injunction can be refused. And where that damage can be compensated by adequate relief, then also injunction can be refused. ಇಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಅವನು ತಡ ಮಾಡಿದ್ದಾನೆ, ತಕ್ಷಣ ಕೋರ್ಟ್ಗೆ ಹೋಗಿಲ್ಲ ಅಂದರೆ ಇಂಜಂಕ್ಷನ್ ಕೊಡೋದಿಲ್ಲ. ಅವನು ಕೋರ್ಟ್ಗೆ ಹೋಗುವಾಗ ಯಾವುದೇ ಒಂದು ಬೇರೆ ಉದ್ದೇಶಕ್ಕೆ ಹೋಗಬೇಕಾಗಿತ್ತು, ತೋರ್ಸೋಕ್ಕೆ ಅವನು ಒಂದು ತೋರಿಸ್ತಾ ಇದ್ದಾನೆ, ನಿಜವಾಗ್ಲೂ ಅವನ ಉದ್ದೇಶ ಬೇರೆ ಇದೆ, ಕ್ಲೀನ್ ಹ್ಯಾಂಡ್ಸ್ ಇಲ್ಲ, ಆವಾಗ ಇಂಜಂಕ್ಷನ್ ಕೊಡೋದಿಲ್ಲ. ಅಥವಾ ಅವನು ಮುಖ್ಯ ಸಂಗತಿಗಳನ್ನು ಕೋರ್ಟ್ ಮುಂದೆ ಹೇಳಿಲ್ಲ, ಅದನ್ನು ಸಪ್ರೆಸ್ ಮಾಡಿದ್ದಾನೆ, ಅದನ್ನು ಮುಚ್ಚಿಟ್ಟಿದ್ದಾನೆ ಅಂತಾಗ ಇಂಜಂಕ್ಷನ್ ಕೊಡೋದಿಲ್ಲ. ಅಥವಾ ಅಪೋಸಿಟ್ ಪಾರ್ಟಿ ಏನು ಡ್ಯಾಮೇಜ್ ಆಗುತ್ತೆ ಅದನ್ನು ಮಾನಿಟರಿ ಕಾಂಪನ್ಸೇಷನ್ ಹತ್ರ ಕೊಡ್ಬೋದು. ಅಂದರೆ ಅವರು ಅಪೋಸಿಟ್ ಪಾರ್ಟಿ ಕಡೆಯಿಂದ ಈ ಹಣದ ಮುಖಾಂತರ ಅದನ್ನು ಕಾಂಪನ್ಸೇಟ್ ಮಾಡ್ಬೋದು, ಅದನ್ನು ಭರಿಸ್ಕೋಬೋದು ಅಂತ ಹೇಳಿದ್ರೆ ಆವಾಗ ಇಂಜಂಕ್ಷನ್ ಅಂಥ ಸಂದರ್ಭದಲ್ಲಿ ರಿಫ್ಯೂಸ್ ಮಾಡುತ್ತೆ ಕೋರ್ಟು. ಸೊ this is a discretion of the court and it is an equitable remedy, and therefore it has to be done to meet the ends of justice. Judicial proceedings cannot be used to perpetuate a wrong committed by a person. Suppose the person comes to the court and just because to harass the other party he files a application for injunction, the court cannot allow such a proceeding. That is stated in Shiv Kumar versus Municipal Corporation of Delhi 1993 and in Gujarat Bottling Company Limited versus Coca-Cola Company Limited. In this case, the court says that just because to give a injury or to cause a damage to the other party or harass the other party, you cannot use these provisions. They are provisions which are used for justice, and on that ground the injunction was refused. So we will discuss this further in the next session with the help of other cases. Also we will be discussing what happens if there is a ex parte injunction, whether ex parte injunction can be given granted, whether notice should be given, and if notice is given what would be the damage done, and then what are the effects of all that, and then if injunction is not followed by the person or he does not obey the order, what is the conclusion or what the court could do. So, looking at all these things, we will discuss these provisions in the next session. And for today, if any questions are there, you can ask me if any questions are there. Any questions, or you have followed? ಸೊ ಯಾವ ಕಂಡೀಷನಲ್ಲಿ ಇಂಜೆಕ್ಷನ್ ಕೊಡ್ಬೋದು, ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಇಂಜೆಕ್ಷನ್ ಕೊಡುವಾಗ ಕೋರ್ಟ್ ಯೋಚನೆ ಮಾಡ್ಬೋದು, ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಇದನ್ನು ಕೊಡಬೇಕು, ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ನಿರ್ಬಂಧಾಜ್ಞೆನ ಕೊಡಬಾರ್ದು ಅಂತ ಒಂದು ಮುಖ್ಯವಾಗಿ ಒಂದು ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಏನಿದೆ ಅದರಲ್ಲಿ ತತ್ವಗಳನ್ನು ಯಾವುದು ಪಾಲಿಸುತ್ತೆ ಕೋರ್ಟ್, ಅದನ್ನು ನಾವು ನೋಡಿದ್ವಿ. ವಿ ಹ್ಯಾವ್ ಸೀನ್ ಅಬೌಟ್ ದ Murli has referred to Kangna Renault case, wherein there are several things. Yes, of course, when the damage has been done to her property, how far it can be compensated, that is the main thing which has been discussed in that case. And therefore, in such cases, injunction cases are plenty, where we have to prove, the burden of proving the case is on the person who asked for the injunction, with the help of the materials before him. So, with the help of the materials, the court has to strike a balance. It is a very, very important power of the court, where the discretion has to be exercised with full justice to both the parties, not only one party. Not that you ask for the injunction and it is given immediately. It has to look into both the things, and it has to balance in such a manner that the convenience should be more, or inconvenience should be caused more if it is not granted, and inconvenience is less to the other party. And of course, prima facie case is the first condition, irreparable injury and balance of convenience come later. So, all these things are to be discussed or are to be considered by the court while granting an injunction. So, we will discuss the other provisions of Order 39 in the next session, and also we will discuss some other cases. And with this, I will be discussing some other cases in a separate session, wherein it may not be part of this session, but it may be a separate session which you will come to know about it. So, you can put your comments, please give your comments, your feedback on this, whether you have liked this, whether it is of use to you, and whether it is of whether anything else is needed. Yes. So, thank you very much, and we will meet in the next session of our discussion. Thank you.